Good morning. In today's class, we are going to have the discussion with regard to drafting and conveyancing. First of all, we'll have the definition of what is meant by drafting. Drafting in legal sense means an act of preparing the legal documents like agreements, contracts, deeds, etc. A proper understanding of drafting, it cannot be realized unless the nexus between the law, fact, and the language is fully understood and accepted. Conveyancing. Conveyancing is an art of drafting deeds and documents whereby any right, title, or interest in an immobile property is transferred from one person to another. We have the drafting definition next. Drafting may be defined as a synthesis of law and fact in a language form. In other words, legal drafting is the crystallization and expression in definite form of a legal right, privilege, function, duty, or status. It is the development and preparation of legal instruments such as constitutions, statutes, regulations, ordinance, contract, will, conveyance, indentures, trust, and lease, etc. The process of drafting operates in two planes, the conceptual and the verbal. Besides seeking the right words, the draftsman speaks the right concepts. Drafting, therefore, is first thinking and second composing. Drafting in legal sense means an act of preparing the legal documents like agreements, contract, deeds, etc. Conveyancing meaning. So first of all, we'll have the meaning of conveyancing. Technically speaking, conveyancing is the art of drafting of deeds and documents whereby the land or the interest in land, that is the immobile property, is transferred by one person to another. But the drafting of commercial and other documents is also commonly understood to be included in the expression. Mitra's legal definition says that conveyancing is an action of conveyancing. It is a means by the way of as an instrument by which the title to the property is transferred as a means of transport vehicle. In England, the word conveyance has been defined differently in different statutes. According to Section 205 of Law of Property Act 1925, that provides the conveyancing, it includes mortgage, charge, lease, assent, vesting declaration, vesting instrument, disclaimer, release, and every other assurance of the property or any other interest therein by any instrument except a will. Conveyance may also be defined in a class of Section 10, Section 2 of the Indian Stamp Act 1899. It includes a conveyance on sale and every instrument by which the property, whether movable or immovable, is transferred and which is not otherwise specially provided by the Schedule 1 of the Act. Thus, conveyancing is an act of conveyancing or transferring any property, whether movable or immovable, from one person to another, permitted by the customs, conventions, and law within the legal structure of the country. There are general principles of drafting, all sorts of deeds and documents and other writings. So the next topic is with regard to it, Fowler's 5 rules of drafting. According to Fowler, anyone who wishes to become a good writer should be an endeavor. Therefore, he allows himself to be tempted by more showy qualities to be direct, simple, brief, vigorous, and lucid. The principle referred to above may be translated into general in the domain of vocabulary as follows. Prefer the familiar word to the far-fetched and prefer the concrete word to the abstract. Prefer single word to the circumlocution. Prefer the short word to the long. Prefer the Saxon word to the Roman. Always prefer active voice to the passive voice in the drafting of documents. Sketch or scheme of the draft document. This is the next topic that we are going to see. It is always advisable to sketch or outline the content of the document before taking up its drafting. This rule is suggested by Mr. Davidson. The first rule of which a draftman must act is that before his draft is commenced, the whole design of it should be conveyed, and if he proceeds without any settled design, his draft will be confused and incoherent. Many things will be done which ought to be done, and many left undone which ought to be done. He will be puzzled at every step of his progress in determining what ought to be inserted and what is to guide him in his decision because he does not know what his own object is. Third point is skeleton draft and its self-appraisal. After the general scheme of the draft has been convinced, the draftman should note down briefly the matters or the points which he intends to incorporate in his intended draft. In other words, he should frame what is called a skeleton draft, which should be filled in or elaborated as he proceeds with his work. Once the draft of the document is ready, the draftman should apprise it with reference to the available facts and the law applicable in the case, the logical representation of the fact, and the use of the simple language intelligible to the layman, and avoidance of the repetition and conceivable misinterpretation, elimination of ambiguity of facts, and adherence to use the Fowler's rules of drafting so as to satisfy himself about his content. The special attention to be given to the certain document. Certain documents, it requires extra care before taking up the drafting. For example, it must be ensured that the contractual obligations are not contrary to the law in the document where the facts so warrant to ensure. Further, in all the documents, whether movable of the property is involved through any of the prescribed modes, it is necessary to ensure the perfect title of the transferor to such property proposed to be transferred by causing investigation and searches in relation to such title done through competent lawyers or solicitors in the consent office of Registrar of Assurance, local authorities, Registrar of Companies in case of the vendor being the corporate unit. In addition to the requisite permission required under the different enactments, the Income Tax Act, Land Ceiling Act, Companies Act 1956 and LISA consent is much more important under the state and central laws, and that should be planned to be obtained in advance and recited in the documents whenever thought necessary. And the final point is expert's opinion. So this is more important as a draftman may have to bear the following points in the principles of drafting. As far as possible, the document should be self-explanatory. The draftman should begin by satisfying himself that he appreciates what he means to say in the document. The well-drafted document, it should be clear to any person who has competent knowledge of the subject matter. The draft must be readily intelligible to the layman, and the document may not be perfect because it says too much or too little, or is ambiguous, or contains one or more of the fact because it has applied in circumstances which the draftman never contemplated. This should be avoided in the drafting of the document. Nothing is to be omitted or admitted at random of the document, that is to say, negative statements. It should generally be avoided. The use of juridical language, it should be made, and the text of the document, it should be divided into paragraphs containing the relevant facts. Each paragraph, it should be self-explanatory and it should be properly marked by use of numbers of letters for the class and subclass and paragraphs. The schedule should be properly provided in the document, and the schedule is the useful part of the document and should contain the relevant information which forms the part of the document. We will also have the discussion with regard to some do's and don'ts of drafting. What are the do's that we have to concentrate? So, reduce the group of the words to single words. Use only simple verb for the group of words. Avoid the roundabout construction and avoid the unnecessary repetition also. Write shorter sentences, express the ideas in fewer words, prefer the active to that of a passive voice sentences, choose only the right word, know exactly the meaning of the words and sentences that you are writing, put yourself in the place of the reader and read the document and satisfy yourself about the content and interpretation and the sense it carries. Here are some of the points that we have to remember for the don'ts. Avoid the use of same words of the same sound, for example, the employer and employee. When the class in the document is numbered, it is convenient to refer to any one class by using single number for it. For example, in the class 2 above. and so on. The negative in successive phrases would be very carefully employed. The draftman should avoid the use of the words less than or more than. Instead, he must use not exceeding. If the draftman has provided for each of the two positions or to happen without each other and also happen without either, it will not be sufficient, and he should write either or both or express the meaning of two in other classes. There are some guidelines for the particular words and phrases that the draftman may have to concentrate. So here they have to make use of legal terms. They may have to refer the legal terms for the legal dictionary, and they can also refer the general words. They have to refer for the general dictionary like Oxford Dictionary, Webster's Dictionary, and the current meaning of the words must be clearly understood, and it is necessary that they have to make use of the words or the phrases that should be properly discussed and quoted in the reference. Technical words may also be used after ascertaining their full meaning and import the sense and the appropriate use warranted by the circumstances for deriving the technical or special meaning with reference to the context. The choice of the words and phrases, it should be made to convey the intention of the executor of the readers in the same sense he wishes to do. The draftman should also use at times the recognized work of the eminent legal expert on interpretation of statutes. In Maxwell interpretation of the statutes, use of some of the words is explained for the guidance of the readers also. The next topic is use of appropriate words and expression. So it is necessary that we have to make use of some appropriate words necessary for the drafting of the documents. The instruments, it should be properly be used as per the definition. It includes every document by which any right or liability or purport to be created, transferred, modified, limited, extended, suspended, and extinguished. Here, a will is also an instrument. At and near, on words are also used in the vicinity and the like. In constructing the description, the word at, when applied at the place, it is less definite in meaning, and in or on, it should be primarily be used. It is a relative word to make use for a location of a real estate. The near signifies relatively greater or lesser degree, and it may be equivalent to at, or it may import the sense of at or along in the expression along the seashore. The word on, when used in describing the location of the land with a reference to some geographical feature, may mean that in vicinity of. The phrase in vicinity imports the nearness to the place designated but not adjoining, generally adjoining or adjacent or contiguous. In absence of anything to the contrary, it indicated indeed that it describes that land conveyed or construed according to the proper and most generally, the intention of the parties is much more important. So, the terms of description may be regarded as having a technical meaning and is controlled by something else in the deed. The word adjoining, it does not necessarily import that boundary of the land conveyed is conterminous with the boundary of the adjoining land. For all that the word implies is contingency, and hence it is equally applicable where one boundary is shorter than the other. It has been held that a common corner will make two tracts of land contiguous. Then next thing is interpretation of the deeds and documents. In formal agreements and in interpretation of the informal agreements, the rule may be applied as under. The expectation, that is to see that the agreements is to be interpreted in the sense that which the party who use the words in question, it should be reasonably have apprehended that the other party may apprehend them. If the intention is manifested ambiguously, the party manifesting the same in an ambiguous manner, it is out to have a reason to know the manifestation may reasonably bear more than one meaning, and the other party believes it to bear one meaning. So, it is necessary that no reason it is necessary to bear the other's meaning that is given to it. Formal agreements. The formal agreement, when written in formal, The following rules of interpretation may have to be applied. A deed constitutes the primary evidence of the terms of contract or a grant or any other disposition of the property. The cardinal rule is that clear, ambiguous, and the words prevail for any hypothetical considerations or supposed intention. In case the terms are not unambiguous, it is legitimate to take into the account the surrounding circumstances for ascertaining the intention of the parties. Sometimes a contract is completed in two parts. At first, an executory contract, it is executed, and later on, an executed contract. In case of the difference between the preliminary contract and the final contract, the terms of the later must prevail. If indeed an earlier class is followed by the later class, which destroys altogether the obligation created by the earlier class, the later class is to be rejected as repugnant and earlier class prevails. The hardship to either party is not an element to be considered unless it amounts to a degree of inconvenience. No clash should be regarded as superfluous, which the merchants are not in the habit of inserting some stipulations to which they do not attach some value and importance. The construction adopted, it should, as far as possible, give a meaning to every word and every part of the document. The construction given to the mercantile documents years ago and accepted in the mercantile world, it should be departed from, and because the documents may be drafted in the faith thereof. In certain words employed in the business or in particular locality have been used in particular sense, they must prima facie be construed in the technical sense. The other grammatical interpretation is not followed, and if it is repugnant to the general context. If in a deed the operative part is clear or intention of the parties is clearly made, whether consistent with the recitals or not, the recitals have to be disregarded, and it is only when the terms of the deed are not clear or ambiguous and the operative part creates a doubt about the intention of the parties, the recitals may be looked into and ascertain their real intention. Sometimes a standard form is used, particularly in contracts with the government, the departments, or big corporations. In these standard printed forms, the words not applicable are deleted according to the requirements of the individual transactions. If any alterations by erasure, interlineations, or any otherwise is made, a material part of the deed after its execution by or with the consent of the party thereto or any person entitled thereunder, but without the consent of the parties or the parties liable thereunder, the deed is thereby made void, but only with the prospective effect. However, an alteration which is not material, that is, which does not vary the legal effect of the deed, is in original state, but which merely express that which was implied by the law indeed was as a originally written, or which carries out the intention of the parties already apparent on the face of the document. The legal implications and requirements. So here are some of the legal implications. Double and doubtful meaning of the intentions given the shape of the document, it should be avoided. Inherent ambiguity and difficulties in the interpretation of the document, the difficulties in implementations of the objectives desired in the document, increased litigation and loss of time, money, and human resource, misinterpretation of the facts leading to the wrongful judgments and causing harm to the innocent person. Thank you.